democracy in general isn't about comfort. It is about responsibility. Like I've said in most of the videos, it is not something we watch. It is something we participate in. We have to sit with the discomfort of these are behaviors people do. These are documented behaviors that people do consistently over time for a long time. And even when people know, they might not report it. And when it's reported, a lot of time it's not believed. And even if it's reported and believed and they go so far as to go through a legal system, the legal system often fails because the words that are needed to talk about the abuse are not even put into law, as we're seeing here with the Arizona bill. This one's intense, so if you want an upper, get an espresso, and if you need something to chill you out, grab a decaf tea, okay? Let's go. I'm choosing to get caffeinated. Hey, I'm Cassie Clayton, and you are on Coffee and Calculated Curiosity. This is week 5 of 52 bills, and this one's on the lines of separation of church and state, and that is a really big issue according to our Constitution. It's bills like this one force us as a public to decide who we protect first. Grab your coffee, bring your curiosity, stay involved. Disclaimer on this bill. It is about clergy having a duty to report abuse. There will be some specific words read out loud. That is my choice for this video. This bill is one that I found in Digital Democracy Project, and it is an Arizona House bill. So we're going to pop right in here to what bills are available as we launch Arizona for Digital Democracy Project. And I can see 10. I was going through here and something caught my eye. Clergy priests' duty to report. This one popped up on a couple of feeds. And I really just wanted to take a minute to figure out if this is what I was seeing. So going right into Digital Democracy Project, pulled up this bill, we can go to the bill text, House of Representatives. This is their second regular session for 2026. This bill is HB, House Bill, 2039, an act amending sections. So anytime we see that, again, that means like something else has already been put somewhere relating to the duty to report. There are sections that need to be amended, in their opinion. We are going to go through it. It is not short, which I also think is rather important. So we want to go find the Arizona Revised Statutes. Okay, we can get to Title 8. So these sections, now let's start here. Okay, the Arizona Revised Statutes has been updated to include the revised sections from the 57th Legislature, first regular session. Please note the next update of this compilation will not take place until after the conclusion of the 57th Legislature, second regular session, which convenes in January 2026. So that's telling us right now, today, in February 3rd, 2026, the 57th Legislature, second regular session is taking place. And the disclaimer is this online version of the Arizona Revised Statutes is primarily maintained for legislative drafting purposes and reflects the version of law that is effective on the first of the year following the most recent legislative session. Now, we're around Title 8 because in the bill, we can see that this is referencing sections 8-201, 12-223, and 13-3620. So we will go look at those sections specifically. And as we start to get into it, we can see it starts immediately with section 8-201. And when we come over here, we see 8-201. So that's how we're matching those up to find out what are they asking to update. Again, we know this is about child safety. In this article, unless the context otherwise requires, adult means a person 18 years of age or older. So if we go back to our bill, they're not starting with adult, right? They're starting with different definitions that they want to include. Okay, then we get into abuse, and we are going to see abuse is not on this list yet, so they're adding that in. They give the definition of abuse. Abuse to the Arizona State Legislature means the infliction or allowing of physical injury, impairment of bodily function or disfigurement, or the infliction of or allowing another person to cause serious emotional damage, as evidenced by severe anxiety, depression, withdrawal, or untoward aggressive behavior, in which emotional damage is diagnosed by a medical doctor or psychologist and is caused by the acts or omissions of an individual who has the care, custody, or control of a child, including an employee or a child welfare agency where a child is placed that is licensed by and contracted with the department. And then it goes into what these types of abuse are. I am not going to read these out loud for the sake of what we're talking about today. This would be vitally important for whoever's voting on this law to be able to read. And we'll talk about why it matters as what's in the law and what is defined in the law. Because bringing charges against someone, there has to be a law where those things are written to prove that that person, when you're attempting to prove that someone did something to you, the thing that they did to you has to be written in the law for a judge to be able to say that is against this law. I know it might not make a lot of sense sometimes in our common understandings of, hey, that's abusive behavior. And if it doesn't say explicitly, let's say, maybe it says if abuse was only physical injury and it didn't also include impairment of bodily function. They could say, well, leaving a kid tied up or put in a cage all day isn't physical injury, so I didn't do anything against the law. And that's why impairment of bodily function is something that has to be written here. And yes, those things have to be written in law for victims to be able to come forward and to say this is against the law, that person needs to be punished in accordance with the law to the full extent of the law. This is where the nitty-gritty takes place of what is it that they could be punished for. That's what's put into law. So the definitions matter. These definitions matter. Words matter. So there is a section on what this includes. There are multiple sections on what inflicting sexual abuse is and physical injury is, unreasonable confinement of a child. So this was abuse. That was a section 2. Then there's section 3. What does adult mean? An adult, we know that is listed here. So instead of adult being the first thing that's going to be on the list, if this bill is passed into law, adult would then become the third item of definition on the list. Abandoned abuse would be 1 and 2. But a child, youth, or juvenile means an individual who is under 18 years of age. Under 18 is a child. Just want to say that a couple more times. Under 18 is a child. Shelter care, I wonder if they have that on here. No, they don't yet. Okay. So we're adding a lot. 8-201 definitions under the definitions tab. So we have 10 things listed. So 201 would be amended to add these additional definitions. And then the whole section, instead of 10 things on that section, would actually be 37 things to provide the state and everyone involved in it more specific definitions of what things mean. So that way, when people talk about, I want to make a change for shelter care, great. What does shelter care mean? Shelter care means the temporary care of a child in any public or private facility or home that is licensed by this state, meaning Arizona, and that offers a physically non-secure environment that is characterized by the absence of physically restraining construction or hardware, and that provides the child access to the surrounding community. So the next section that's catching a lot of attention for this bill is 12/2233. So if we go back to those statutes, we know we're in section 8, probably title 12. Okay, courts and civil proceedings. Let's go look if that's what we're doing. 12/2233. I would have thought I was looking for 22. Maybe it's a different order. Those are 31, 24, 22. Okay, evidence. Oof, that took a minute. Okay, it's under chapter 13. I was not expecting that, but we can find anything, honestly. Here we go. Privileged communications. And this is under evidence. So we need to go to 12/2233. And here we see what's currently listed. Clergyman or priest. And for those who are unfamiliar with penitent, let's go look that up. Someone who's feeling sorry for repentant. A person who repents of their sins or wrongdoings. In the Roman Catholic Church, a person who confesses their sins to a priest and who submits to the penitence that he imposes. So this word might be unfamiliar to you if you are from a different faith background, a non-faith background, a different spiritual background. It is important to look things up because this definition might be unfamiliar to you if you're from a different faith background, a non-faith background, a spiritual background. And that is what this means. So we want to be talking about what is actually in the bill. In a civil action, a clergyman or priest shall not, without the consent of the person making a confession. In a civil action, a clergyman or priest shall not, without the consent of the person making a confession, be examined as to any confession made to him in his character as clergyman or priest in the course of discipline enjoined by the church to which he belongs. I believe this is saying that if you made a confession, the priest can't be examined based on what he heard in the confession unless the person making the confession consents to the priest telling the information that was said. Okay, so let's see what they're asking for here. They're looking for this change. The change would be, in a civil action, a clergyman or priest shall not be examined as to any confession made to him in his character as clergyman or priest in the course of discipline enjoined by the church to which he belongs, unless the clergyman or priest determines that the confession involves ongoing abuse. So that's where we need to then go back up and we would have to look again back on this page. What is the definition of abuse? And this would then indicate that a clergy man, person, human, or priest would have to know the definitions of abuse and the examples of said abuse, who the abuse was against, because this is going to have in the next implication. So they would like to update this section and take out without the consent of the person making a confession. Let's get back in. We're not quite done. The next section to be revised, 133620. Now, so this is a different title. So we're going to go back up to 12. We're going to switch 12 to 13. Now we see the criminal code. 133620. I'm guessing it's going to start at chapter 36 maybe. So let me close all the chapters. Here we go. Chapter 36. 3620. Arizona State Legislature, 3620. Okay, this one's a little bit longer. We have some more definitions. This section is called Duty to Report Abuse, Physical Injury, Neglect, and Denial, or deprivation of medical or surgical care, or nourishment of minors, medical records, exception, violation, classification, definitions. Okay, that's what this whole thing is concerning. We're going to also make sure that we all have the definition.
Deprivation.
Of deprivation, meaning the damaging lack of material benefits considered to be basic necessities in society. Sleep deprivation, oxygen deprivation, withholding of nutritious food, clean water, safe shelter, clothing, healthcare, education, sanitation. Back to the duty to report. Any person who reasonably believes that a minor is or has been the victim of physical injury, abuse, child abuse, or a reportable offense or neglect that appears to have been inflicted on the minor by other than accidental means, or that is not explained by the available medical history as being accidental in nature, or who reasonably believes there has been a denial or deprivation of necessary medical treatment or surgical care or nourishment with the intent to cause or allow the death of an infant who is protected under Section 36-2281, should find that, shall immediately report, cause reports to be made of this information to a peace officer, to the Department of Child Safety, or to a tribal law enforcement or social services agency for any Indian minor who resides on an Indian reservation, except if the report concerns a person who does not have care, custody, or control of the minor. The report shall be made to a police officer only. So here's where we're going to get into this section and the differences. And we're going to highlight those. So we just read this section that's on the law, right? And we just read to made to a police officer only. So what they would like to change, a member of the clergy, that's that next section we were just about to read, a member of the clergy. So let's go read what they're wanting to change. A member of the clergy, a Christian Science practitioner, or a priest who has received a confidential communication or a confession about abuse that has already occurred while serving as a member of the clergy, as a Christian Science practitioner, or as a priest, the course operating under the course of the discipline enjoined by the church to which the member of the clergy, Christian Science practitioner, or the priest belongs may withhold reporting of the communication or confession, unless the member of the clergy, Christian Science practitioner, or the priest determines that there is reasonable suspicion to believe that the abuse is ongoing, will continue, or may be a threat to other minors. So this is the update, part of the update. There are more updates. Okay. This exemption applies only to the communication or confession and not to personal observations the member of the clergy, the Christian Science practitioner, or the priest may otherwise make of the minor. For the purposes of this subsection, person means any physician, okay, any peace officer, the parent, school personnel, any other person who has responsibility for the care or treatment of the minor, member of the school district. Okay. So in this section already, we see just a couple of changes. What they're mainly wanting to take out is this sentence that says, The priest determines that it is reasonable and necessary within the concepts of the religion, because they were saying the priest may withhold reporting. So here it would have read, they may withhold reporting, and we can go read it over here. Currently, it says, may withhold reporting of the communication or confession if the member of the clergy, Christian Science practitioner or priest, determines that it is reasonable and necessary within the concepts of the religion, that they would not have to report the abuse if someone confessed to the abuse in a confession when they were in their priest role, is how it's this person's role. That's how it's reading right now. And the exemption applies only to the communication or confession, not to the priest's personal observations that they might also be seeing. So what the law would like to clarify, the group that is bringing this up, is saying we want to take out that the priest has to be in their role if someone's making a communication or a confession about abuse that has already occurred. And we want to take out, even if the priest is operating under the course of the regular discipline that the church has. And instead of if, it says unless the member of the clergy, the Christian Science practitioner, or the priest determines that there is reasonable suspicion to believe that the abuse is ongoing, will continue, or may be a threat to other minors. So this is separating out someone who, let's say someone abused a minor 50 years ago, and they're finally confessing it to a priest, clergy, Christian Science practitioner. And this person is no longer there. They're not living in the same place. That person's not a minor anymore. But they're confessing to this previous abuse. The priest in this case does not have to report that to anyone because that person is no longer abusing a minor and the abuse is no longer ongoing for what they can tell from the scenario. If this person who's making a confession is the clergy person, priest, practitioner, Christian Science practitioner, believes that the abuse might be still ongoing to a minor, even though this person has confessed in a confessional, the priest would then be required to report that abuse. So this is shifting to. So keep going down. A member of the clergy, a Christian Science practitioner, or a priest who has knowledge or a reasonable suspicion that a person is committing or may commit child abuse or neglect shall immediately report or cause reports to be made of this information to a peace officer, to the Department of Child Safety, or to a tribal law enforcement or social service agency for any Indian minor who resides on an Indian reservation. Because there are specific different laws for if someone resides on an Indian reservation or not. Except if the report concerns a person who does not have care, custody, or control of the minor, the report shall be made to a peace officer only. So if this was seeing someone else abuse a child, but that person doesn't have control of that child, then the report is only made to a police officer. If this is about someone who does have control or care of the minor, the reporting needs to go into multiple locations. This subsection does not apply to a confidential or penitential communication unless the member of the clergy, a Christian Science practitioner, or a priest determines that the abuse or neglect is still ongoing or will occur in the future. That is a little bit subjective, that priests would have to determine if the abuse or neglect was still ongoing or will occur in the future. People in these positions who hear a lot of confessions are also able to hear how people talk about things, to notice differences in how people behave. That would be something to note in this bill. All right, so then all these sections are being moved down. That's why the letters are being changed, because they added B. So then the one that was B becomes C, D, etc. So that's all the way through. Any person other than one required to report or cause reports to be made under subsection A or B, since we added B. That's the change here. Notwithstanding any other statute by the Department of Child Safety, the department shall immediately notify a police officer in the appropriate jurisdiction. Okay. Adding that or B now. That's being added in. A or B of the section may take or cause to be taken photographs of the minor and the vicinity involved. Medical examinations of the involved minor may be performed. I was a foster mom in the state of Texas, and for certain kiddo situations, if there is suspected abuse, there are medical examinations that are performed by doctors at children's hospitals specific to these types of incidences to verify if they can see that abuse has taken place. Medical examinations might look different for the different type of abuse that is being claimed. Okay, these are keep moving down. Here's another section that we're adding something in. So we should read the whole thing. In any civil or criminal litigation in which a child's neglect, dependency, physical injury, abuse, child abuse, or abandonment is an issue, a member of the clergy, Christian Science practitioner, or priest shall not, without his consent, be examined as a witness concerning any confession made to him in his role as a member of the clergy. A Christian Science practitioner or priest in the course of the discipline enjoined by the church to which he belongs, unless, now this is the new section here in blue, unless the member of the clergy, Christian Science practitioner, or priest determines there is reasonable suspicion to believe that the dependency, physical injury, abuse, child abuse, or abandonment is ongoing, or that dependency, physical injury, abuse, child abuse, or abandonment may occur in the future. So they're opening up the ability for this clergy, priest, practitioner to be a witness concerning the confessions that have been made. This subsection does not discharge a member of the clergy, practitioner, or priest from the duty to report pursuant to the subsection A or B of the section. Okay, so we're going to keep going. We're on page 11. These just keep moving down, and that is it. Woo, it's a longer bill. Where is the bill now? The bill was pre-filed in December. It was first read in the House January 12th, and then there was a second reading in the House on January 13th. So let's talk about pros and cons of passing this bill. Getting into Digital Democracy Project. Clergy priest duty to report. What are some pros of putting a bill like this into place? Promotes a culture of transparency and trust in society, demonstrating that child welfare is a universal priority, overriding religious confidentiality. Increasing accountability and oversight, such as religious institutions, must adhere to the same reporting standards as other organizations. Protects vulnerable children by ensuring that all instances of suspected abuse are reported, potentially preventing further harm. I think what we're seeing in the pros here is this bill exists because of the history of abuse that's in the churches, and where abusers might be held accountable by the church, but that doesn't mean that their actions stop. Across decades, investigations have shown that many churches and religious communities, institutions, however you want to talk about them, do not report abuse. They might say that they will, but they don't. They keep the records, they move the offenders, they handle abuse internally, they protect clergy and fathers while children continue to be harmed. So this bill in Arizona is not something that's isolated. It's not something specific to Arizona. This is not specific to the Catholic faith or Christian Science faith or evangelical faith. This is institutions protecting themselves. And when systems consistently choose reputation over safety, the law has to step in because they're not going to report things themselves. Mandatory reporting has to happen with very specific definitions, or else there's continual loopholes to say, well, that wasn't the exact thing that happened, so this law doesn't apply here. And that perpetuates victims never being able to have justice. Some of the things in the pros here that we should talk about are protecting children under the definition that Arizona is bringing up. It's anybody under 18 years old. So a minor, a youth, a juvenile, a child. Under 18, it is not on them to have to report the abuse. Other professions already carry these responsibilities. So teachers, doctors, they have to report abuse when something like this comes up or they see it. Clergy has been maybe the only exception, and very small exemptions at that. The bill is not specific to any specific belief system. This applies across any belief system. And it does impose the responsibility when harm is known and ongoing, there is a duty to report. This bill actually exists in multiple states. There are similar laws in New Hampshire, West Virginia, North Carolina, and Texas. Arizona is not an outlier here in wanting to put this law into practice. It would be joining existing legal trends that are trying to ensure children are safer in any space that children exist, even in the home, if someone's reporting that abuse. Because again, this is not the priest seeing abuse happen or seeing a child that has bruises. This is someone telling that priest, confessing to that priest that they are abusing or they are being neglectful in those definitions, that they are depriving a child. This is someone saying out loud to the priest to alleviate the guilt that they might be feeling. So this is not something that a priest is making up. This is saying the priest heard this information and it appears to be ongoing. The priest has a duty to report. In Australia, Canada, France, Ireland, there are legal duties to report that override confession secrecy. Some of the costs to implementing this bill are being described as putting an additional burden on clergy. They may face moral dilemmas and legal consequences when determining whether to report confessions. Certainly. I would like to highlight that that would apply to anybody. That would apply also to teachers. That would apply to doctors. That would apply to the neighbor down the street who watched abuse happen. That would apply to someone who's at CPS. Everyone faces moral dilemmas or legal consequences potentially when determining whether to report abuse. This is specific to clergy reporting confessions. May deter individuals from seeking spiritual guidance or confession, fearing their private matters could be disclosed to authorities. So this is saying, well, someone might not feel comfortable telling their priest that they are abusing their child, abusing a minor that's in their care, abusing a youth, abusing a juvenile who is under their legal control. And they might not go to church anymore, which would be a choice. They are the ones who are wanting to assuage themselves of the abuse that they are doing. We have a high culture in America of wanting to get into heaven, and in different religious beliefs, you get into heaven different ways. Going to confession and doing penance is one way that a type of faith gets into heaven. Third, challenges the role of clergy as confidential counselors, potentially leading to a breach of trust within religious communities. So we should talk about confidential counselors. Because what is said, this is not a paid lawyer. A clergy is not a paid lawyer. And even if you go to a therapist who is paid to be a therapist, If you detail specifics about abuse, therapists have a duty to report. If you go to a counselor at school and talk about specifics of abuse, those school counselors have a duty to report. This is getting into the issue more specifically around church and God, a higher power governing the people that are under that belief system versus the government being involved in that. And at that point, I think we need to stop and think about children being able to make decisions for themselves about who are governing them when they are under an adult's care, an adult's control. Children are not able to have their own jobs, their own homes. They don't go to the grocery stores by themselves. They don't make money for themselves. They have an adult caregiver, whether that is a parent or a state guardian. Children have a caregiver. Children are generally not picking the religion that they are going to either. So children aren't born deciding my parent is going to be part of this religion or not be part of a religion at all. Because if a child decided my parent is not part of a religion at all, that parent might not be protected by church. But opponents are also raising points around confession being sacred in many faith traditions. Clergy are not investigators. They're not medical professionals. There is a concern about the government intrusion into religious practice and the fear that abusers will stop confessing altogether. These concerns deserve our respect because we do have the separation of church and state as part of our United States Constitution, right? So that is in here. They're not frivolous. We cannot throw them aside even if we have strong opinions one way or the other. These exist alongside the reality that confidentiality without accountability has failed children over and over and over. This is not a moral place for a moral debate. We are looking at the bill and making sure that everyone has the information they need to then go forward and think about how they would want to vote, how they would want to talk to their legislators, how you might want to look up if this is a bill in your state or not. I think the question that this would come back to is, what does your faith base say about child abuse? And we see very often that people who claim a faith base of any sort then still can be abusers themselves just because they are part of a religion does not make them immune to being a human and does not mean that they won't create or be abusive or oppressive in those situations as well. Something else to think about is when an adult knows a child is still at risk, who carries the responsibility for that? If a child has been groomed to expect the abuse, to think the abuse is normal, if they don't see a different model of adult around, does that child know that how harmed they are? Where does the adult step in? Where does the community step in? And at that point, should the whole community not respond? I think what's hard here is bills like this one force us as a public to decide who we protect first. Let's talk about what you want to do with this information next. If you are in Arizona, you are going to want to look up your legislative district and contact your House representative because this bill is in the Arizona House. So let's just go to a super fun map, and I'm going to make sure the map is in my notes. Okay, so you can get it later. And let's pretend, do we have a favorite number? Like number 19. Let's say we're in District 19. Oh, so it's on the outside of Tucson, so not even in Tucson. We can look at some information about it. All right, approved district. We want to go and find out who our representative is for Ledge District 19. House of Representative members. Let's go to 19. Now that we know we have 2 people. So these are the 2 people that we would want to be emailing. We'd want to email Gail and we'd want to email Alupe. And we could click on these specifically and input the information to talk to them about this bill. What are we going to say about the bill? Let's go to VoteBot and get some suggestions, okay? Pop that VoteBot right back up. We're in Digital Democracy Project, and let's do the standard prompt. At this point in time, if you've been rolling with me, we're on week 5 of 52. So that means you're going to use this prompt pretty often. What I would suggest is that you have it saved because you're going to ask VoteBot about it every single time. Yeah? Okay, I'll throw it in a thing so you can find it there too. Okay, so throwing that prompt inside VoteBot, we're going to wait for a response to come back, and then we would be able to take that response, read through it, update it to what it's going to be. Here we go. We have some statements. Let's look at these. So if we were in support, we wanted to maybe copy paste. Let's see if we could take it from here or if we need to edit it a bit. I strongly support House Bill 2039, which would require clergy, priests, and other religious leaders to report suspected child abuse or neglect, even if the information is obtained during confession or privileged communication. Protecting the safety and well-being of children must come first, and no institution should be exempt from the duty to report abuse. Please vote yes on House Bill 2039 to ensure all children are safeguarded from harm. That would be a great support statement. You could copy and paste that over in the contact information right here to Lupe. Awesome. And then definitely always ask for a response. If they have it, that's always kind of nice to know that they looked at it. An opposition response. I oppose House Bill 2039 because I believe it threatens religious freedom and the confidentiality of religious confessions. The relationship between clergy and their parishioners relies on privacy and trust, and mandating clergy to report disclosures made in confession undermines this sacred practice. Please vote no on House Bill 2039 to protect religious liberties and the integrity of confidential spiritual counsel. That could be something that you want to send in or make a little bit of updates to before you sent it exactly the same way in that contact field. And then a neutral statement, something just knowing and letting your representative who you have put into office know that you are looking at what they are doing or what they are not doing, what they are supporting, what they are not supporting. A neutrality statement. I am writing to express my interest in House Bill 2039 regarding the duty of clergy to report abuse. While I appreciate the need to protect children, I am also concerned about the potential conflicts of religious confidentiality. I urge you to carefully weigh both the rights of religious communities and the need for child protection as you consider this bill. Please ensure that any action taken balances these important values. Now, you could ask VoteBot here to tailor the language, maybe specifically you're concerned about individuals not going to confess anymore, or you are concerned that priests won't know to do a report. How are priests going to get the updated reporting? And you might say, let's use this as an example. Let's say I support the bill. Or let's say I'm neutral on the bill, but I feel like it should have more things in here. I strongly support, so here's my little edit. Ooh, it's hard to see. So maybe we would say I support the bill. Let's ask VoteBot. I support the bill. I am concerned that priests won't have the training or updated legal awareness to report. How is that being handled? And you should ask your legislature, how is that being handled? Because if what we've covered today tells you anything, it has to be written in the law for it to be used later, whether to protect a victim or to protect someone who wasn't actually an abuser. Either way, the law specifically, with the words that it uses and the definitions it has, matters. Okay. Proposes to require clergy members, including priests, to report suspected child abuse, neglect, even if the information was learned through privilege or confessional communications. The latest version of the bill does not specifically outline any mandatory training or education requirements for clergy regarding their new duties. The bill mainly focuses on removing exemptions from clergy to do reporting. So in the concern that you would want to pass on to your legislature, you might want to say there needs to be mandatory training so people in the clergy know how to spot child abuse. That would be something that I would find is maybe missing from the bill, something to be added or amended. These are the bills to spend our time on. There's a lot of things that are put out there to be very polarizing or to just grab some attention and using a waste of time where things are already in law. This is one that deserves actual time and sit down and people to weigh out the pros and cons and then make a decision that the law can push up behind them. Something that's a pattern that we should talk about is when institutions of any kind consistently fail to protect the most vulnerable, the responsibility shifts outward. This bill doesn't ask faith communities to abandon their beliefs. It asks them to reckon with the power that they were given and maybe look at if that power should shift going forward. In an ideal world, this type of bill would not be needed. If everyone always did the right thing, we wouldn't need child protection laws at all. Laws aren't written for people who are already doing the right thing. They're written for the moments when power, fear, or self-interest get in the way. We know these bills are needed because we have decades, very upsetting decades of records showing what happens when we relied on people doing the right thing. Morality and laws aren't opposites, they are layers. We write laws at the point where values repeatedly fail to protect people who had no power. And that's often the least of these, which are children. Child abuse is something that we see frequently in any state, in any country, in any family, in any ethnicity. These are not specific to only one group or only one location or only one faith-based. Faith does ask people to do the right thing, and then the law steps in when history shows that faith didn't stop the harm. Democracy doesn't live in absolutes. It lives in really hard spaces where values collide and choices have consequences. Thank you for taking a sip with me. I'll see you next time.